All right, good morning, everyone. We are part two of Purchase and Sale 2025 GAR contract. Just as a reminder, we are not lawyers, so these are opinions and interpretations. So you should consult your broker, which might be me, and an attorney if you have any questions. So we will get moving with that. All right, we're going to go relatively interesting today. We're bouncing back and forth between the actual PDF and some slides just because some of the information is quite long. Last time we made it through section 9 on the first page, so we are to number 10, which is the brokerage relationships in this transaction. This is a good time to remind you how brokerage relationships work. um, so, as the listing agent, you're the seller's broker, right? If it's listed in FMLS, they are a client, so you're going to check that first one, unless, of course, one of your fellow Remax Metro Atlanta Center agents is representing the buyer, in which case you will want to select item number 4, which is the designated agent, right? And then your name goes in the seller side, and the friend that is working with the buyer goes in the buyer side. Dual agency, obviously, if you are representing both sides, you would mark that. Please make sure that you've done proper disclosures and things. We'll talk more about that when we do the buyer and listing agency agreements, or seller agency. And then, of course, working with a client or a person as a customer means that you are not advising them. You're solely providing that transactional information, right? So you are just putting that information on paper that they want you to. And then finally, the material relationship disclosure. Dan, you and I are pretty good friends. If you were
Yes,
representing me in a transaction, would you say that there was a material relationship there?
of course.
Of course, because as with all disclosures, if you think there might be something to disclose, it never hurts to disclose it. So it just makes it easier. So we kind of go from there. All right, first jump here. Let's jump over the purchase and sale agreement, and we'll scroll down to section 10, which is a little long to be copying and pasting. Let's go a little wider so you guys can see better. Is that good?
Yes.
All right, so this again goes through the agency disclosure. It goes through what we basically just said, right? Like that there's no agency relationship, that there's a consent to dual agency. So if the box that says dual agency is checked, you need to make sure that all of this is through here. The designated agency disclosure, um, compensation of the brokers is under. It explains it here. It's kind of interesting that they moved it into this section, but this is where it's explained where that might be talked about. And then, of course, disclaimers basically says that while you may be our client, you haven't relied on anything stupid we've said to make decisions about buying this house. So things to think about from that perspective. Um, any questions about the agency section? All right, let's jump to 11. 11 is the time limit of the offer. I'm writing an offer today. It happens to be the morning. What should I set as the expiration for the offer? Should I go noon today? Anybody?
That's tight.
That's tight, right? I would label that's an asshole, because that's real tight. I think you got to be reasonable with people, and I think it's important as part of the relationship that you hopefully are having with the other side, whether you're the buyer's agent or the listing agent, you have some idea of what their situation is, right? Is their client in Japan, or is their client um, elderly, or is their client on a work retreat, or is their client, like, are there things that might cause abnormal delays that you might want to compensate for? What happens if this timeline passes?
The offer dies.
The offer dies, right? Now we can revive it with some creative paperwork, But at the end of the day, it's a lot easier if you give yourself enough time to work through whatever it is you want to work through. The other thing to notice here is initials. Initials are on the first page because that's where most of the blanks are. And we want to make sure that both parties have actually read that page. So from a legal perspective, that's why they add that on there. Let's go down here to section 11, which is super short. I could have pasted it on there, but I was in this mode. So let's talk about time limit of the offer. The offer, it expires unless prior to that date, it's been accepted by the party to whom the offer was made and notice of acceptance of the offer has been delivered to the other party. Do we know what notice means? Well, what a great segue into our further sections into the contract. So we've done all the fill in the blanks basically at this point on the first page, but we're only on page 5 of 10. So there's lots more information in here that we need to talk about. So let's talk about notices because that is a part of that time limit. That notice of acceptance has to be delivered. So I can't just sign it and put it in the drawer and then 3 weeks later say, yep, we were under contract. Because if I didn't tell the other side that made the offer that we were under contract, how are they going to know, right? Like we need to have notified them. So generally notices can be have to be given in writing, legible, which thank God most of the things we do now are on the computer. So from that perspective, we get a little bit more legibility. And then of course, sign, which leads to oh, well, we do a lot of things on the computer. We need to make sure that everything is signed if it's a notice, right? In the event of a dispute of a notice, the burden shall be on the party giving the notice to prove delivery. So here are the requirements of this notice paragraph. And this is true even before this becomes binding, all right? Notice shall only be delivered in person. How many people do that? Anybody? Pretty rarely. By courier, overnight delivery service, or certified or registered U.S. mail, collectively referred to as delivery service. Anybody do that? Not typically, right? By email or facsimile. The person delivering or sending the written notice signed by a party may be someone other than that party. So that means that we're sending a notice signed by our client, and that's still valid, right? So we talk about the delivery of the notice. The delivery of the notice shall be deemed delivered and received upon the earliest of the following: the actual receipt of the written notice by the party. So like if you're handing it to them, well, obviously that's when it was delivered. In the case of a delivery service, when that is delivered to the address of the party set forth, and provided that a record of the delivery is created. Hence why you wouldn't just put it in the mail and hope for the best. You have to use registered, certified, overnight, or courier, or something that has some kind of record of when it was delivered. And in the case of electronic delivery, on the date and time, the notice is electronically sent to the email address or facsimile number. So in other words, if we send it, that's when it's delivered. Doesn't matter that agent B doesn't open it for 6 hours or 2 days or whatever. We sent the notice at the time, and because it's electronic and it's immediate, it's considered delivered at that moment. We are obviously, the next paragraph talks about when we're authorized to send. One of the things that's important to understand is that if there's not a fax number or an email in the signature line, are we able to email or fax notices?
No.
No, right? We have to have that information on the contract in order to be able to do that. So that's an important thing to understand. This section just goes through the, when you can send. And then it also says here, right? Sent to the authorized agent. The authorized agent wherein is not opened, except in physical address, and authorized to receive the notice. Okay. All right. Let's go to default. Default is an important piece. So, well, actually, let's go back 1 second. So I've signed the offer. What is my notice of accepting the offer to the other party?
Finding it and sending it back.
Emailing it to them, right? I'm going to email it to them, and it's effectively delivered as soon as I emailed it to the email that's in their signature, right? Now, if we know that they have another email address and, it's one of those agents that has like 8 email addresses, like some of us do, you can add others. That's fine, but you have to make sure that you include the official one. It's kind of like back in the day when people had to fax things to the brokerage fax number, to make it official, even though the agent had their own fax number that it would get sent to. That's no longer the case. And to be honest, I find more and more contracts that don't have fax numbers in the signature, which is perfectly fine with me because I think faxing is where legible becomes an issue, even with digital faxes at this point. All right, let's go to default. Remedies of the seller. If this fails to close due to the default of the buyer, the seller's only remedy or sole remedy is to retain the earnest money as full liquidated damages. They can't go after anything else. They're actually signing in here that that's it. You need to explain that to a seller because some sellers, especially those that happen to be attorneys, like to get a little aggressive about those sorts of things. I've been off the market for 60 days. That's money out of my pocket. You owe me. Okay, well, then you should have asked for more earnest money. And so this is a great way to explain, in my opinion, why earnest money is important and how much earnest money you're getting. Is that enough to realize that if this property is off the market for 35 days or whatever it is between now and closing, is that going to be satisfactory as liquidated damages? So it's important for you to look at that. Remedies to the buyer. In the default that the buyer, default of the seller, the buyer can either seek specific performance, which means force the seller to sell it to them. Can a seller force the buyer to buy it? No, right? We can't. There are other buyers out there, but there's only one house like this. So the buyer can force the seller to sell them this property. I have never seen that go smoothly or functionally in my 20 years. I see, Debbie, you're laughing at that, but that is, it's not a path anybody really wants to go down. But I have seen some situations where we've leveraged that to, I'd say, be aggressive in the contract. And then, of course, the buyer has the right to terminate it, in which case they get their earnest money and other payments the buyer has made towards the purchase of the property shall be returned to the buyer following the procedures set forth elsewhere. The buyer may also pursue other remedy available at law. So, buyer has paid for inspections, has paid for appraisals, has put money down. Maybe they paid option money. Let's get into that for a question. I've paid option money, which is non-refundable, right? I paid it directly to the seller. Seller defaults on the contract. Should I expect to get that option money back?
Yes.
You should. And Debbie, you're muted if you're chiming in. But yes, you should expect to get that money back. It is non-refundable under the terms of the contract being honored. If you fail to close because you fail to close, that's different than if the seller defaults on the contract. So that is something that you should take into consideration. Rights of the broker. This is one that often gets overlooked. But if this terminates or fails to close due to the default of either the buyer or the seller, the defaulting party shall pay as liquidated damages to the broker in the transaction the compensation the broker would have received had the transaction closed. So if the buyer changes their mind, defaults on the contract, not uses a contingency to get out of the contract, not terminates their due diligence or normal things, but defaults on the contract, then you as the agent representing them can get them to pay you. Now, they will never work with you again, but sometimes that's a choice, right? And so that's one of the things to look at. attorney's fees, any litigation or arbitration arising out of this between any of the parties, the non-prevailing party shall be liable for prevailing party for all its reasonable attorney fees and expenses. It's spelled out. So oftentimes you have to countersue, right? You have to say, well, if you lose, you're going to pay my attorney fees. This is right here in the agreement. So it's just part of the contract that they have to pay that. Any questions about defaulting? All right, keep moving along here because we're still only on page like 6, right? Yeah, page 6. All right. Risk of damage to the property. This is an important one. Seller warrants that at the time of closing, all items remaining in the property, if any, will be in substantially the same condition. Obviously, there's exceptions of defects and blah, 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 as of the offer date, except for the changes made for the condition pursuant to the written agreement. If the property is destroyed or substantially destroyed prior to the closing, seller promptly shall give notice to the buyer of the same and provide the buyer with whatever information they have available for insurance, disposition, and all those sorts of things. Buyer or seller may terminate this agreement without penalty not later than 14 days from the receipt of the above notice. Understand this is one of the few things that the seller has the right to terminate the contract. If the house gets crushed by a tree and they notify the buyer that the tree has crushed the house, the seller may terminate within 14 days of providing that notice and walk away. Buyer's going to get their earnest money back, but the seller can walk away and kill the deal. If neither of them terminate, the seller shall cause the property to be restored to the same condition. The date of the closing extended to the earlier of 1 year. It's a long time. 1 year from the original closing date, or 7 days from the date that the property has been restored to the same condition. So you effectively have to close 7 days after it's finished, up to a year later, which is a lot, but things to consider. All right, condemnation. If for some reason the property is condemned, then the seller needs to provide notice to the buyer regarding that. The buyer here shall have the right, but not the obligation, for 7 days to terminate upon notice to the buyer. On notice to the seller. If the buyer does not terminate, the buyer agrees to accept the property less any portion taken by condemnation, and if the buyer closes, the buyer shall be entitled to receive any condemnation award or negotiated payment for all the portion that's been not conveyed in lieu of condemnation, if that makes sense. I have never involved in anything like that. I think that would fall more under where like a right-of-way, roads being widened and taking away some of the property might be something that might apply here. If you're talking a whole building that's been condemned, I'm not sure why you'd want to move forward with that, because obviously you don't have anything when you're done. Consent to share non-public information. This is the thing that allows the attorney to share and distribute the ALTA statement. Delays caused by emergencies. This one was leveraged the other day. Well, not the other day, but the other month or whatever. In the event the governor of Georgia declares a state of emergency for the county in which the property is located, all time deadlines herein, including but not limited to the closing date, shall be automatically extended for the number of emergency exists in that county. And you can agree to mutually proceed without that extension, but that extension happens automatically. So governor declared a state of emergency a little while back with a snowstorm. Behold, if your county was in that snowstorm emergency, your contracts were all extended by that 3, 4, 5 days, whatever it was. So be aware of that. You can leverage that if you need to. Digital signatures. Digital signatures are as good as originals. Duty to cooperate. Hey, if you need something, we're supposed to provide it. Entire agreement. This is it. If it's not added, amended to this contract, there is nothing else being done. This is part that's here in the contract. And of course, at closing, most lenders require everybody to sign that there's no additional agreements outside of this agreement as well. So let's make sure that that's all part of this. Extension of deadlines. No timeline, no time deadline under this agreement shall be extended by virtue of falling on a Saturday, Sunday, or federal holiday, except for the closing. So if the closing date happens to fall on a weekend or a federal holiday, not a local holiday, federal holiday, then that closing automatically gets extended. There are many, many people that use a special stipulation that apply that to all deadlines, which I'm a fan of personally. But, you know, just be aware that this already has in here that the closing. So when you're trying to count days and all those sorts of things and get your closing date right, don't stress too much about putting it on the wrong date and ending up on a weekend or something. I mean, I think it's better to look at a calendar, but you know, whatever. FERPTA affidavit, the foreign person, this is additional taxes being withheld at closing. If you are working with a foreign person, which is kind of an interesting statement, but let's just say someone that's not a US citizen, then that is someone that is going to probably need to have additional taxes withheld and provide more information. So GAR forms. Hey, these are the GAR forms. You have to be a GAR member or have paid the fee to be able to use these forms. GAR is not liable for how bad they might be or how good they might be. And you can't change them, if that makes sense. Come on now. All right. Governing law and interpretation. This agreement may be signed in multiple counterparts, each of which shall be deemed to be an original and shall be interpreted in accordance with Georgia law. Okay, does everybody know what that means? Does anybody know what that means? No? So what that means is you don't have to all sit together and sign it all at the same time. It can be signed in multiple counterparts. And it can be signed, you know, different documents, actual documents. But it is going to be all amalgamated together, and it works if everything is the same. It doesn't really apply to us much these days because most people use e-signatures and all these signatures end up on the same document anyway. The broker has no authority to bind. Okay, we cannot bind the contract. We say we bind the contract. Robin said it earlier, I think, but we technically are not the one binding. We are filling in the ministerial, we are doing the ministerial act of filling in the binding agreement date, but we are not the one actually binding it. The binding happens when the signatures of the parties happen. No recording of the agreement. We are not going to record this agreement or any portion of it. In this case, the buyer is really the one not allowed to record it because they would be the one that might try to do something like that. I've never seen that happen, but you know, I guess they could try. The notice of binding agreement date. The binding agreement date shall be the date when a party to this transaction who has accepted an offer or counteroffer to buy or sell real property delivers notice, remember, delivers notice of that acceptance to the party who made the offer or counteroffer in accordance with the notices section of the agreement. Notice of the binding agreement date may be delivered by either party or the broker working with or representing such party to the other party. If notice of accurate binding agreement is delivered, the party receiving notice shall sign the same and immediately return it to the other party. This is the extra form that you can use that we'll talk about later. Notwithstanding any other provisions to the contrary contained in the agreement, it is the express intent of this section that one, a broker or licensee involved in the sale, real estate transaction may perform the ministerial task of filling in the binding agreement date, and two, sending a fully signed purchase and sale agreement with a specific binding date included that one of the parties has agreed to constitutes notice of the binding agreement date to the other party. Okay, now it gets really fun. Objection to the binding agreement date. How many people have been involved in transactions where people didn't agree on what the binding agreement date was? I have. It's not fun. This is the paragraph that will save you. If the buyer or seller objects to the date entered as the binding agreement date, then within 1 day, so 1 calendar day, from receiving notice of the binding agreement date, the party objecting shall send notice of the objection to the other party. The objection shall be resolved by the written amendment between the buyer and seller by executing a binding agreement date confirmation, F733, one we were talking about a minute ago. The absence of an agreement on the binding agreement date shall not render this agreement unenforceable. The failure of a party to timely object will result in the parties accepting the binding agreement date as entered. So there's a lot of stuff between the lines there. We don't agree, buyer and seller don't agree on the binding agreement date. It's off by 1 day. Doesn't mean that the contract is not enforceable. It means the contract is fully valid and enforceable. The problem comes to, when do my deadline, my contingencies end, right? I hope to never be in that situation, because typically you work it out and agree on something. But if you don't, you're still going to proceed forward and do your thing. Now, I would recommend, to alleviate future issues, try to get your stuff done at the earlier of the discrepancy dates. But if you can't, and you have, if you're, because sometimes people argue about the binding date and they're wrong, right? Like it should be a day earlier. No, it shouldn't. I signed it today, not yesterday. You made the offer yesterday, but I signed it today, right? So just know that that's going to be a fun process. Try to get it worked out in the beginning if you can. That's what we're here for, is to help with that and make sure that that goes smoothly and try to get everybody on the same page. Property be delivered in clean condition. This is one of my favorite special steps I see all the time, that people automatically write in or default to including with their little list of special steps. That notwithstanding any other provision to the contrary of the time possession, seller shall deliver the property in clean condition, free of trash, garbage, debris, pets, and personal property of the seller not otherwise identified as remaining with the property. This section shall apply even in transactions where the property is being sold as is. So it no longer uses the phrase broom clean, which was always questionable as to what that meant. It is in clean condition. That is obviously a personal opinion. So you're going to have to deal with that. But free of trash, garbage, and debris is pretty straightforward. If there's a pile of trash in the backyard, that's supposed to be gone. Now, how many times is it going to be gone? Not very often. Most of the time, it's probably still going to be there. If it's there and the house is vacant when you're showing it and writing the contract, it's probably going to be there when you close. So things to think about when you're looking at properties. If you absolutely want something like that gone because your buyer doesn't want to deal with that, you should put that in the contract, that you should be specific, that pile of debris in the backyard to be removed 24 hours prior to closing at the cost of the seller, right? Because that's a specific thing. Anything that's left in the house, what happens to it? All that personal property that somebody left in the house, you got that hoarder house that nobody got everything out of. Whose property is that now that we've closed? Buyers.
Buyer.
Yep, buyers. So that is something to think about. Some people love that. Some people hate that. So it's just one of those things to go. All right, this is the hierarchy of rules of interpreting the agreement. Rules for interpreting the agreement. Handwritten changes shall control over pre-written, pre-printed, or typed provisions. Okay, so if you come back and handwrite something, that's going to drive. If you exhibits shall control over the main body of the agreement. So if you have an exhibit that says something different than what the main body does, then that's going to win. Special stipulations shall control over both exhibits and the main body. This one gets a little confusing because special stipulations are kind of in the main contract, right? But they actually will override the exhibit. Notwithstanding the above, the amendatory clause in any FHA or VA exhibit shall control over inconsistent or conflicting provisions contained in another exhibit or special stipulation. Let's clarify that. What that means is that if you have an FHA exhibit, for example, and you write a special stipulation that says there shall buyer's earnest money shall not be refundable in the case of the property not appraising. Does that special stipulation carry any weight? No, because the FHA exhibit overrides that. FHA appraisal through closing, period. You cannot undo that. Federal programs. The amendatory clause in the FHA and VA control over inconsistent provisions contained elsewhere in the agreement. The buyer and seller acknowledge that further agreement pertaining to a mandatory clause section does not conflict with or is not inconsistent with the mandatory clause. Exception as otherwise provided. Agreement and any amendment thereto shall be enforceable as between the parties, even without the signature of any broker referenced herein. Hey, we are not parties to the contract, so our signatures aren't necessary to make things enforceable. Notwithstanding any above, if the agreement including a provision for the amendment hereto changes the total amount of compensation due to any broker, then said broker has previously agreed to, then such change to the broker's compensation will only be binding if the broker impacted to such change consents to the same in writing. In other words, you can't insert a paragraph or an exhibit, the old F-259, for example, that changed the listing broker's compensation. If the listing agent didn't sign that, then that didn't change their compensation. Now, this paragraph is different than what it used to be, so it's better. But just those sorts of things to think about. If the broker has any special stipulations herein, the party for whom the special stipulations were written confirms that such stipulation fully and accurately reflects that party's intentions, accepts each stipulation as if it were written by such party, and hereby agrees to indemnify and hold the broker harmless. GAR contracts protect GAR members. That's why we use them. This is an example of that. We are writing specific stipulations, which we are legally allowed to do, even though some states refer to that as practicing law. But this paragraph says very clearly that, hey, if I wrote a special stipulation for you, Mr. Buyer, you are agreeing that you've looked at it, and if you don't think it's right, you're going to tell me, and you're not going to do anything about it if it is wrong, because I'm not liable for it. Which that's a whole different argument. We'll keep going. If the broker answers a question of the buyer, or otherwise describes some aspect of the property or the transaction, broker is doing so based upon information provided by the seller rather than the independent knowledge of the broker, unless the broker makes an independent written disclosure to the contrary. So everything you say is supposed to be just a repetition of what the seller told you. If you know something that the seller hasn't told you, that's a whole different conversation we need to sit down and have. All right, moving along. Statute of limitations. 1 year from the date of any claim. So you got a 1 year portion after that. Survival of the agreement. This is an important one we all know. Survival of the agreement, any the obligation of the party to compensation, the warranty of title, written representation of the seller in the agreement regarding the property or the neighborhood in which the property is located, buyer's indemnification obligations arising out of the inspection of the property by the buyer and the buyer's representative, section of the condemnation, section on attorney's fees, obligations of the parties regarding ad valorem real property taxes, obligations set forth in the devices and fixtures section, seller's liability for not timely removing items from the property that the seller agreed to remove, and any obligations which the parties herein agree shall survive closing or may be performed or fulfilled after closing. All survive. Anything that's not on that list does not. It all dies with closing. Important to understand that. Terminology, as the context may be required in the agreement, the signature singular shall mean the plural, vice versa, and all pronouns shall mean and include the person, entity, firm, or corporation to which they relate. So in other words, you can't, if I said he instead of she, that's not a voidable reason for the contract. That's a mistake, but not voidable. And then, of course, time is of the essence. I love it says time is of the essence. Time is of the essence in this agreement. Okay, well, maybe you could have explained that a little better for people that don't understand. So you can't just drag your feet, right? Like you can't stall. You got to do things in a timely manner. All right, let's go through some definitions because this is an important section. Banking day. A banking day shall mean a day on which a bank is open to the public for carrying out substantially or all of its banking functions. A banking day shall mean Monday through Friday, excluding federal holidays. Interesting, right? Because Monday through Friday, how many people have banks that are open on Saturdays? They're open, but are they actually doing deposits and things? Some of them do, some of them don't, most of them don't. So Monday through Friday, excluding federal holidays. If I write in my due diligence that it's 5B or 5BD, is that sufficient to reference banking day? No, it's not. So please, 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 just because the definition of banking day is in here, if you're going to use it, you need to spell it out, that it is banking days instead of calendar days. Binding agreement date, obviously, is the date on which everybody accepted. Once that occurs, the agreement is considered binding. Broker, in the agreement, the term broker is mean the licensed real estate broker and firm that are affiliated. Business day also could be labeled BD, right? But business day shall mean any day in which all businesses are open. Business day, Monday through Friday, excluding federal holidays. So technically, business days and banking days are similar, but whatever. Client shall mean the parties who's represented by a broker. Closing shall be the event in which the parties can consummate the transaction. We're not going to go through all the ways. We all know all the different ways that you can consummate the transaction. Compensation, term compensation and used in the agreement shall mean the compensation to be received by broker for performing real estate brokerage services. Okay. And that doesn't matter if it's flat fee, percentage, bonus, or some other method of compensation. Technically, they could give you a car. I've seen that once upon a time back in the crazy days of real estate. But we try not to do that anymore. It's real hard when we have to cut off part of the car to take our portion as the brokerage. People don't like it. It's not fun. But anyway, the term customer shall mean a party or parties who are not being represented as clients by a broker. So that's important. Day, you notice they don't say calendar day. They just say day because that's the way it's referred to in the contract. For the purposes of the agreement, the term day shall mean a full calendar day ending at 11:59 p.m., except as may be provided for elsewhere here within. Counting days to determine deadlines, the specific date referenced as either the binding agreement date or the date from which the deadline shall be counted will be day 0. This is important when you have an agent that doesn't know how to count. The easiest way to explain this, in my opinion, is if you had a 1-day due diligence and we went under contract today, would it end tonight or tomorrow night? Well, of course it would end tomorrow night, right? It wouldn't end tonight because that would not be a day, right? Like that would be insane. So most people can get it if you explain it that way. Material relationship, we talked about that, it can be any actually known, personal, familial, social, business, doesn't matter. But again, if you have something to disclose with a material relationship, I assume that it is always better to do it. The use of initials in A or in /A or in A dot in filling out a blank in this agreement shall mean not applicable. I did a thing the other night where the special steps page or the additional changes page on a counteroffer was blank because we didn't have anything. I put NA so that it was clear that I didn't just miss it or something got deleted. That to me is the use of NA, is to make sure that everyone is aware that we didn't just forget to fill that out. We are saying that that is not applicable to this contract. Okay. All right, moving along here. I'm not going to make it today, Robin. It's 9:44. All right. Warning to buyers and sellers: beware of cyber fraud. I mean, if people aren't aware of cyber fraud at this point, they have been living under a rock. It still happens. I know clients, not mine, but clients that I'm aware of, and agents that have been involved in transactions where hundreds of thousands of dollars have disappeared. Please, please, please point this out to your clients. Please, please, please remind them over and over again through the transaction. As you get closer to closing and they're starting to wire money, remind them not to wire money to the person that emailed them the wiring instructions, because that is not something that a closing attorney will do these days. And if they do, you need to use a different closing attorney. So please, please, please make sure that that is true. Number 7 is kind of an interesting one. It's the procedures to help prevent fraud and a covenant not to sue. Again, GAR contracts protect us. If we determine, or anyone in here determines, that there's some fraud happening, we have the ability to push that forward and not be sued. So that's basically what all of this says. So make sure that if you smell something funny, that you look at it, and let's report things that are funny, because that helps protect our consumers. Big all bold paragraph, literally A and B both bolded, limits on broker's liability. We will never, ever, ever have any liability greater than the amount of the compensation paid hereunder to the broker, excluding any compensation amount paid to a cooperating real estate broker, if any, or if no compensation is paid to the broker, the sum of $100. So there you go. If they lose $100,000, you could theoretically owe them $100. That's it. All right. We did make it to where I wanted to make it. Believe it or not, we're a little bit over, a couple of minutes, because this exhibits addenda. We're going to go through these as we go through them. One thing to note here is that we want to make sure that everybody is aware that when you fill this out, please make sure that your letters correspond correctly here with the ones that are there. Make sure you check the box next to the one that you want to include. Don't not check the box and just put a letter. There's all kinds of those types of things that cause issues. Special stipulations, that's a whole nother class we'll go into. Signature information, let's quickly review this. I represent the buyer, so I write out my offer here, and I put their name here for them to sign. Am I going to fill out this information here about the address and the phone number and their email address?
No.
No, not if I represent them as a client, because I want all of those notices to come to me, correct? If they are unrepresented, then absolutely we're going to put their information there so that they too have the way of getting notices, either by delivery, in person, or via email. Same thing for my sellers, right? If I represent them as a client, there's no need to put any of their contact information on here. That just leads to issues. Conversely, when we're representing our clients and doing these types of contracts, it is professional courtesy to go ahead and fill in the other person's information. Please don't be lazy about this. It's just rude. If you leave the seller's broker information completely blank, that means you didn't bother to go into FMLS or Georgia MLS, click on that agent, and get their information. It's all right there, one click away. It's not that complicated. The only thing you might not know is their realtor membership. Fine, leave that blank. But come on, people, let's put their information in here. Let's put the brokerage information. Let's fill it out as best we can. And then, of course, this is the ever important binding agreement date box. And so this is the what the date is and who filled it in. If your seller signs the agreement and fills in that date and writes their name there, is that acceptable?
Should be.
It is, 100% it is. Anybody involved in the transaction can bind to this transaction. Typically, it's the agents, but I've had clients over the years that wanted to bind it themselves. Fine. Put in the date and write your name out. That's how it's going to be bound. But you have to be the one accepting the offer to be able to bind it, right? So that's the only piece there. Questions, comments as we wrap this up. Our purchase and sale we've wrapped up, so we will go into other parts of the contract starting next week with me fresh off of my beach trip to Cancun. So just plan on me being a little tanner, not quite as pasty. Any questions?
Yeah, I have a question about, you said we don't want to fill in the contact information for the buyer and the seller, but then earlier in the contract, you said that the emails had to match up.
So that is for notices. And so if these parties are represented by their agents, the notices are going to go to the agents. So we want to make sure that we have, if you don't have a fax number here under the agent, I can't use fax as a delivery method. If I don't have an email address here, I can't use email as delivery. That is true if you're sending notice to the buyer or the seller, then their information needs to be in here, but we're going to do all of our notices through the agents that represent them if they're represented. And the agency agreement that we have with that party is going to give us that information to be able to provide notice to them and that relationship. So it's not necessary for it to be on this agreement. Good question, though, because that is sometimes people get confused on that. I mean, the only harm in putting it there is that now the buyer and seller have each other's information. And sometimes people get crazy and send things or call or do whatever that they shouldn't be doing because we all know that it's not great for parties to talk directly. That's why they hire us. So we are the intermediaries from that perspective. So just something to think. All right. Alrighty. Cool. Thank you guys for coming. And we will see you next week. Tell your friends and share the video. We'll put it out on our YouTube channel, and feel free to share it with those agents that need a little help in understanding the contract. We'll talk to you soon. Thanks.
Brett, enjoy your
Have fun.
vacation.
Bye, guys.
Bye.
Bye.